You're listening to Economics Detective Radio. My guest today is Peter Leeson of George Mason University. He is the author of WTF, An Economic Tour of the Weird, which will be our topic for today. Peter, thanks for being on Economics Detective Radio.
Thanks for having me.
And I should also note that Peter's the author of The Invisible Hook and other books, but The Invisible Hook is about pirate economics, and it's definitely worth checking out, especially if you find this conversation interesting. So WTF is a sort of anthology of different sort of strange and unusual practices that, Peter, you explain them in terms of economic theory. So what would you say is there a general thesis and an overarching, message to the book or a general idea?
Yes. At the most basic level, I think the general idea is that all human behavior, including and perhaps even especially that behavior that doesn't seem to make any sense, in fact, does and is quite rational. Okay.
So, let's jump into some of the specific cases. Your first chapter is about rational choice theory and that the overarching idea that, economics can be applied to these problems. Your second chapter is called Burn Baby Burn, and it's about judicial ordeals, like a trial by fire and water. So what is a trial by fire and water?
Well, for about 4 centuries, between the 9th and the 13th centuries in particular, accused criminals their fate was essentially determined by them being asked by the legal system to plunge their arm into a cauldron of boiling water to pluck out a ring or a stone that had been thrown in there. That was called the trial by boiling water, the ordeal of boiling water. There was another hot ordeal variety, which involved having an accused criminal carry a piece of burning iron a certain number of paces. And then there was a cold water ordeal, which wasn't hot at all, as the name suggests, and involved dunking the defendant into a pool of holy water. In the hot ordeals, if the water or the iron burned you, you were considered guilty of having committed the crime of which you stood accused. And if it didn't, you were innocent. And in the cold water ordeal, if you sank, you were considered innocent, and if you floated, you were considered guilty.
So they made fun of this on Monty Python and the Holy Grail, where they are having a witch trial, and they concluded, so if she is heavier than a duck, then she is a witch, and kind of making fun of what seems like a nonsensical practice. But your take on it is that it does make some sense, or it can make some sense. How does that work?
Yeah, I think that it does make a tremendous amount of sense. And in fact, its basic features look not terribly different from the basic features, once you strip away from its surface features, from the features that we would expect and in fact do observe in any reasonable legal system. And when it comes to criminal accusations, in particular, the central problem that any legal system confronts is one of private information. Only the defendant, the accused, knows for sure whether or not they've committed the crime of which they've been accused. And everybody else is just trying to make more or less an educated guess of some sort, hopefully on the basis of some kind of evidence. And so what all legal systems want to do in order to render just outcomes is to somehow figure out how to tap into the defendant's private information about his guilt or innocence. And medieval Europeans' way of doing that was actually pretty clever. It was to ask God to tell them whether or not the accused had in fact committed the crime of which he stood accused. And that's a pretty good idea because, after all, God is omniscient. He sees everything, right?
In theory, I guess they would believe that.
Of course, I was kidding just a little bit. The important part of this is that, as you just pointed to, people believe that, right? So in the Middle Ages, there was a popular superstition, a scientifically false belief, which was the foundation for these trials by fire and water. And that belief is called Judicium Dei, the idea that ordeals reflected judgments of God. And essentially the thought was that, if priests performed the appropriate rituals, and I should point out, it's important to know that priests were the one who in fact conducted ordeals of all sorts. If priests performed the appropriate rituals, they could ask God to tell them whether or not the accused was guilty or innocent, and God would tell them by, performing a miracle, for instance, to show that the defendant was innocent in the trial of boiling water, for example, or to let the water boil him to show that he was guilty, if that was in fact the case. And the critical sort of economic element to think about here is how, if you believed in such a superstition, as I argue people in this period in Christendom did believe, how it would affect your incentives differentially to be willing to undergo something like the trial by boiling water, depending upon whether or not you in fact had committed the crime or hadn't. And the underlying logic is extremely simple. So if you believe that God's going to out you if you've committed the crime, you expect that when you plunge your arm into the boiling water, that the water is going to boil you. And so that means not only that you're going to be convicted of having committed the crime and thus face whatever the punishment is for the crime of which you've just been convicted, but importantly, you're also going to have your arm boiled to rags, which is not a very joyful prospect for most. That means that what you might want to do, and in fact what many people, it turns out, did do, was simply confess to your crime instead. At a minimum, you're still going to suffer whatever the punishment is for being convicted of admitting to this crime, but at least you're going to save your arm from being boiled. Conversely, imagine that you know that you didn't commit the crime, right? You're in fact innocent. Well, you expect that if you plunge your arm into the boiling water, that God's going to perform the miracle that prevents your arm from being boiled. And as a result, you'll be exonerated and your arm won't be harmed at all. That makes it sensible for you, if in fact you haven't committed the crime, to be willing to plunge your arm into the water, because that's better than if you, say, confessed, in which case you'd be punished for a crime you hadn't committed. So innocent people have a dramatically lower cost of undergoing the ordeal than guilty people, which means that we can infer, and in fact medieval legal systems did infer, I argue, from the way in which an accused criminal chooses with respect to his willingness to undergo the ordeal, whether or not he's in fact innocent or guilty. If you're willing to undergo, you're probably innocent. If you're not willing to undergo, you're confessing typically, so you're guilty. So effectively what you have happening is trial by boiling water, correctly finding fact in difficult criminal cases.
Right. So you could imagine in our modern world, if people believe that jury trials or bench trials, but criminal trials generally exonerate the innocent and convict the guilty, then we would expect that people will plea bargain if they're actually guilty and go to trial if they're actually innocent. And at that point, given those beliefs, you wouldn't even need to really do a trial, given that they have already self-sorted into guilty and innocent. Of course, it's not that simple in the real world. The trials are messy, and sometimes innocent people get convicted or guilty people get exonerated, and so it doesn't necessarily always work like that. But in this world where people genuinely believe, assuming the accused genuinely believes, that the trial by ordeal is going to either punish him if he's guilty or let him go if he's not, then they will self-sort like this. But here's the issue. Wouldn't they actually just get their arms burned?
Yeah, and that's the second sort of pretty neat aspect, I think, and tricky aspect of thinking about these judicial ordeals. So it's exactly the right question to ask. So, the innocent guy, only the innocent, let's suppose in the very simplified version of what we're talking about, are willing to put their arms in the water, but what happens when the boiling water burns them? In order to correctly produce just outcomes here, it's not just that the medieval legal system needs to know that you're innocent, it needs to actually find you innocent. And the key to making that happen is the water needs to not boil you. And the key to making water not boil you is to make sure that the water that defendants stick their arms into is not, in fact, boiling. And so what priests did, I argue, was effectively turn down the dial on the stove, so to speak, such that the water that defendants, who were called probans, I keep on wanting to call them that, so if I refer to probans, that's what I'm referring to. But the water that defendants plunged their arms into was, in fact, tepid, or the iron that they supposedly carried was, in fact, not burning, so that it wouldn't harm them, which did two things. not only did it have this self-confirming sort of reinforcing feature, it confirmed the innocent defendant's belief that the ordeal was in fact a judicium Dei, a judgment of God, but it allowed the judicial system to find the outcome that it in fact needed to.
So in, I guess, modern game theory terms, we might say that this mechanism is not actually incentive compatible because, if you really understood the way the mechanism works and you were guilty, then you would, do the trial by ordeal and be found innocent, presumably, because you could game the system if you figured it out. But the important thing is that people's beliefs were not accurate, and that's what made it work.
Yes, exactly. I mean, I don't know that I would say it's not incentive compatible. I think that the key to it is that it is incentive compatible, conditional on people holding the superstition. The superstition is precisely the thing that makes it work, right? Obviously, this doesn't work if people don't hold the false belief. But as you point out, our modern system, you referred to trial by jury, for example, and jury trials are, at least by some law and economics scholars, have been pretty roundly criticized in some regards because there's no particular reason to think that 12 quote-unquote randomly selected peers are going to be particularly good at finding fact in the case before them. But it doesn't matter, right? As you were getting at before, as long as people believe that the jury is likely to get at the heart of the matter, then they're going to ultimately behave in the way that allows us to proceed in the manner that we want to proceed. So the key to this, in fact, several of the other unusual social institutions and practices that I consider in the book is built on this idea of these scientifically false beliefs in particular contexts being adhered to, being believed in. Which gives additionally a sort of way for thinking about the existence and in particularly, I think, the persistence of certain superstitions and scientifically false beliefs. I think a lot of times people wonder, are puzzled by, in this context, for instance, how it is that for the better part of a millennium, people could believe in something so crazy as the idea that God would intervene to perform a miracle to prevent water from boiling you if you hadn't committed a crime. But when you start to see how it permits criminal justice in an environment and context in which criminal justice might not otherwise be possible, you start to see that it's quite a socially productive belief in some sense, which, at least from an economist's perspective, goes a long way, I think, toward explaining why we see it lasting for so long.
I'm having a moment of realization where if it's the case that jury trials are not particularly accurate, then you could make the case that maintaining a noble lie that they actually are accurate all the time would be socially beneficial, and pointing out their injustices and inaccuracies would actually sort of break the system. Then it makes innocent people take plea bargains and guilty people go to trial and then could cause damage. I'm not sure how I feel about that, because it feels like finding the truth should be telling people the truth about things should be socially beneficial. Let's go on.
I was just going to say real quick, I can do you one better on that, which is that one of the things that I've likened medieval trial by ordeal to and discuss at some length in the book is in the contemporary world is polygraph tests, lie detectors, which are totally bullshit. I mean, there is about as much scientific validity to the idea that you could physiologically measure whether or not someone is lying or telling the truth as there is in astrology, or in the idea that God performs miracles to prevent boiling water from boiling innocent people for that matter. But as long as people believe that polygraph tests function that way, they can be effective detectors, in fact, of truth and falsity. But some people have given me a hard time about sort of publicizing this fact, because the reason it works is grounded in the superstition, which is popularly held, by the way. Many people with whom I speak are surprised to learn that scientifically polygraph tests are bogus. But so I guess maybe I'm doing my part towards unraveling that one, which is no good.
Yeah, it's kind of strange. It's strange that a myth could make the legal system work better, but the reasoning checks out. I want to skip ahead because since we're on the topic of medieval legal systems and justice, of course, most people are going to be familiar with Game of Thrones, and whenever someone's on trial in Game of Thrones, they demand a trial by combat, and people in the Game of Thrones universe believe that the gods will make the correct side, your champion will win if you are innocent and will lose if you are guilty. Seems like a very costly way of doing things, and kind of maybe the characters in Game of Thrones are they all seem fairly secular, like they have this religion but they don't really believe it, and they seem to believe that the strongest fighter will win. So it doesn't seem to work for them. But your eighth chapter is called Fighting Solves Everything, and talks about the use of trial by battle in land disputes in Norman England. So tell me a little bit about that. How did that work?
So the basic idea is that in Norman England, when there were difficult property disputes, and I should point out that almost all real property disputes in this period were difficult, because if I claimed that I owned a parcel of land and you claimed that you owned a parcel of land, often, overwhelmingly, we did not in fact have charters, like deeds basically, that we could point to that were reliable, that the court could use to figure out the answer to the question of to whom the property actually belongs. And so, you could use witnesses, and witnesses were in fact involved in Norman England's legal procedure for trying to establish who owned a contested parcel of property. But what the primary mechanism, the most important piece of this, was that what judges would do when they confronted such a case, which is, again, as I say, was quite often, was that they would order the two litigants to hire legal representatives, which sounds very much like what happens in adversarial systems today, and in many ways is similar. But rather than these legal representatives being advocates, verbal advocates for their respective litigants arguing a case before court, what the judges ordered the legal representatives to do would be to club one another, to physically fight, to combat before an arena of spectating citizens. And these legal representatives were called champions. And the winning champion's employer, the litigant who he represented, would be awarded the disputed parcel of property. That was trial by battle.
Was it a fight to the death usually?
No,
Okay,
it was not.
good.
In fact, there are, I believe, no recorded cases in which anyone actually died. So one of the things that the legal system did, I argue, likely as a means of trying to reduce the sort of procedural cost of this mechanism for allocating disputed land, was that it ordered the champions to use non-lethal weapons. So they used clubs, not swords or axes, and they donned protective gear, shields and so on. And obviously you could, and people did sometimes get injured in the fight, but deaths were extraordinarily seldom, if they happened at all.
Okay, so yeah, that's that makes a lot more sense than Game of Thrones, because it would be very costly if every legal dispute resulted in a very skilled champion fighter dying. You would quickly run out of people like that, and I don't think many people would have willing champions, people willing to, take a 50-50 shot at death just to resolve someone else's property dispute, even for quite a bit of money. Reminds me of the myths about Roman gladiators, that someone was killed in every fight, which of course was not the case. So tell me about the economics of this. How does it make more sense than doing something, sometimes we do have disputes today where there's a lack of evidence and it's hard to determine who's right and who's wrong. And we still try to hash out the facts and make arguments and different claims and judge who's lying and who's telling the truth. Tell me a little more about the economics of how would this get the correct outcome.
Well, in Norman England, they also tried to hash it out. So this was the sort of, to try to figure it out when they could again. This was a last resort, but it ended up being an extraordinarily common resort, because the argument ends pretty quick when we're trying to hash it out, or I should say the discussion ends pretty quick when there really isn't anything to go on other than people's competing claims I should say more or less equally plausible claims to having rightful claim to the contested land. And in modern systems, yes, you're right. I mean, that certainly can happen too. And the judicial system ends up making some determination about who the contested parcel should go to. And the key thing there is that, even if they get that wrong, the economic, so let's say they end up assigning it to the wrong party, the economic effects are pretty minimal because, we've got this idea of the coast theorem. And so regardless of who the judges assign the disputed land to, we might not be getting correct who it should properly go to from a rights perspective. But from an economic perspective, we've got good reason to think that it really won't matter that much because in the end, that land is going to flow into the hands, the other litigant, for example, if this applies to him, who values the land more, who values the property more. And the reason, of course, is that he will be able to, in principle at least, because if transaction costs are low, he'll be able to purchase the parcel away from the party to whom the legal system awarded the land. So real property is flowing into the hands of the person who values it the most because of functional markets, essentially, regardless of what the legal system does. In Norman England, though, that wasn't true. And the reason it wasn't true was because of feudalism, which everybody has heard of. And, one of the, I think, underexplored or underappreciated aspects of feudalism is that what it did was make real property rights, in particular, extraordinarily sticky, meaning that whomever a parcel of land was awarded to via the legal system would end up being more or less something close to like the permanent holder of that land. And the reason for that is that feudalism connected almost everybody in the system, incidentally, through this elaborate web of feudal relations, of lords and subservience and so on. And the upshot of this is that in order to basically protect people that a person might be connected to in the feudal chain, if you wanted to sell your property, you needed to get permission from the guys who are connected to you in the feudal chain, because it might ultimately affect their material interests. In fact, it almost certainly would affect their material interests, to whom that land that you were looking to sell ended up in the hands of. So you had to get lots of people's permission. And because you had to get lots of people's permission, it was really expensive to basically trade land. And as a result, there was basically no market in land, and land seldom moved from one person's hands to another's through market exchange. And that matters a lot because going back to the same idea, if the judge allocates the property one way in Norman England, and that person is not the person who values the land more highly, who has a more productive use of the land is going to stay in his hands, which can have serious long-term adverse economic consequences, especially when you imagine that this is going to be happening economy-wide. It's not a one-off scenario, but it's every time there's essentially a property dispute. So it was especially important in Norman England for judges, when they couldn't figure out who was the rightful owner of a parcel of property, to at least do the next best thing they could, which was to assign the property at the outset to the disputant who valued it more. And the way that they did that, I argue, was through this institution of trial by battle, which essentially functioned like a kind of auction, albeit a violent auction, that did precisely that. And the reason it did that was that the litigant who valued the contested parcel more was going to be willing to spend more money on a champion, and the champions who commanded higher prices tended, of course, to be the champions who were more likely to win in the arena in an actual trial by combat. And so what you had is the guys who value the property more spend more to hire a better champion, and probabilistically that means that they're more likely to end up getting the contested parcel of land, meaning that the land tends to wind up in the hands of the guy who values it more.
Yeah, so it seems like you could get around this by, say, each writing down a number and putting it in a sealed envelope, and then you open the envelopes and each pays. The one who wrote the higher number gets the land, and they could both pay the money to the state, or it could be just sort of a, well, yeah, I guess they would have to both. It would have to be sort of an all pay thing, because you wouldn't want people to be able to profit by making claims to other people's land. So there's a little bit of waste here, but there's also some reason behind it. It makes sense that although this is wasteful and the payments to champions are probably a noisy measure, or the odds of a champion winning conditional on the size of his payment is a noisy measure of who values the land more. But yeah, it does make some sense.
I just wanted to say real quick on the point that you make about the waste in the system, which most certainly there was. At the same time, I try to argue that the very specific detailed particulars of how the system worked, I think were an attempt to minimize that waste. So we talked already a little bit about, guys not dying, but more generally, these features of the system, for instance, using this particular type of auction where the auction receipts flow to the champions rather than to, say, the state, I argue was also purposeful. It was a reason why violent auctions were used in sort of a regular sort of ascending bid auction, or this sort of standard auctions that we think about, because of rent seeking in particular. So think about money flowing to the state. I argue that, in fact, in this period, the greatest source of rent seeking came from, or threat of rent seeking anyway, came from the state. So if bid receipts are flowing to the judge or flowing to the king, let's say, he has a quite strong incentive to try and basically find property disputes, perhaps even to initiate them, where they don't really exist, which undermines what private property security there existed. Now, the same problem existed to a certain extent with respect to champions. Just like in our contemporary legal system, you've got the idea of the sort of ambulance chasing lawyer. The same thought might apply here in the context of champions. But I argue that, in fact, champions were in a less powerful position with respect, or less influential position with respect to being able to generate such property disputes than the state was, which is one reason why you'd want an auction system where the receipts of the auction flow to champions as opposed to flowing to, say, the state, which would be the case if they use the sealed bid auction format to which you referred, for instance. So socially
Right.
wasteful, yes, but the particular features, I think, actually evolved to minimize the social waste and explain those features.
Right. So it's kind of like cases where the revenue from speeding tickets goes to the local government, or even worse, the police department that issued the speeding tickets. And then, of course, you get instances where, for instance, there was a town in Florida that shortened the length of the yellow lights so they could catch more people with their red light cameras so that they could get more revenue, which of course just makes every intersection much more dangerous, but it was sort of a sneaky way to get revenue, and that came out of the fact that the same organization that was creating the rules of the road that people would then maybe violate was getting income from people's violation of those rules.
Exactly.
Maybe there's something more to this also being a huge spectacle, because of course, if you resolve this dispute like somehow quietly, off in a private courtroom or something, what's to stop the loser from just going and acting like they won, going and sending some peasants to farm that land or something? If it's a big public, I assume these fights were public and had audiences and people watching. And so everyone in your community would then know who won. And so you couldn't then feign ignorance and, go against the court's ruling thereafter because everyone knew what the outcome was. Is there something to that?
Absolutely. I think you're spot on. There's the public information component to which, the sort of common knowledge aspect that you're referring to, which I think is critical. But there's another aspect to it too, which is as basic as it gets. And that's people find it entertaining to watch other people fight. And so, part of the potential social cost of the system, people getting injured and so on, is converted here into non-appropriable by the state anyway social benefit, which is people taking in the spectacle of watching two champions clash. And these were the battles for which we have the best records anyway, were very well attended events. It seems that people quite enjoyed this.
I can imagine. So I'm going to make an awkward segue here. So you argue that that these fights were a form of auction. Let's talk about a different form of auction in a different period of England's history. During the Industrial Revolution, there were apparently wife auctions. That seems... I can't believe I've never heard of this. Is it true that people would auction off their wives?
It's true. It's true. In fact, I actually came across this practice. So there's a famous novel in which wife sales feature that's placed in Industrial Revolution era England, which is when these things were happening. But that's not how I heard about it. I came across the practice when I was actually doing my research on pirates, back when I was writing about pirates. One of the books I was reading referred to it, and I just sort of made a note like, what the hell is this? He referred to auctioning off a wife as a way of dissolving one marriage and starting a new one. And I just sort of flagged it as something to which I wanted to return. And then, years later, I did exactly that. And with a couple of friends and colleagues of mine, Pete Bettke at George Mason and Jamie Lemke, also at George Mason, what we did was we actually, wanted to get firsthand records of this stuff because it seems like it couldn't be true. There's a lot of these things, just as an aside for a moment, a lot of these things, they all seem absolutely crazy, I think. And some of them just seem like, how could this possibly be? Which incidentally is the same feeling I had when I came to study back on pirates again. When I was finding out about the pirate flag, Jolly Roger, I just thought, I was sure when I got into the history of it that even though I'd heard about it and I'd heard some historians refer to it, that when I looked at the documents myself, it was going to be clear that this was just like, a Hollywood fiction that we have sort of fell in love with. And so, we talk about it like it was real. But lo and behold, I found out, the Jolly Roger, the Skull and Bones flag, that was a real thing and an important thing. And so too, it turned out to be with English wife sales. And the records that we used were the actual advertisements for the sales that people would make in newspapers of the time. So it was like classifieds for, who wants my wife? She's, it would maybe list off a few of her attributes, and at a minimum, it would give the time and place at which the auction was going to be conducted. And they were ordinary marketplaces where livestock was being auctioned off. So it would be wives alongside, cattle. And one of the neat things about the ads was not only that they were advertising before a wife sale occurred, but we also were able to get some information on the prices at which they transacted, because oftentimes, not always, but oftentimes a public notice would be made also in the newspaper ex post saying, such and so's wife has been sold. Here's the price for which she was sold. Here's the person to whom she was sold. And that was important basically as a way for creating, common knowledge again about the effective transfer of property rights, so to speak, of a wife's status as a wife of one husband to becoming the wife of another. So there ended up being pretty neat and most certainly compelling records on which we were able to dig into the practice.
So this is so strange and also hilarious. You suggest in the chapter that this is maybe kind of an end run around divorce. The divorce rules weren't so lenient back then, and so this institution sort of got around the restrictions. Is there must be more to it than that.
Yeah, so that's a critical part of it. You're right. Part of it getting an official divorce in this period in England was basically impossible. Not quite impossible, but almost impossible. You literally required an act of parliament on your behalf dissolving your marriage, and it was extremely expensive, and as a consequence, out of the reach of most working class people. Really, out of the reach of all working class people. A few wealthier people could afford it, and a few of them actually managed to get a divorce that way. Everybody else had kind of like, these sort of de facto divorces that involved the church that could exist. They weren't technically divorces. They were basically like, separations where you could live apart, and they required the husband to pay some alimony, but the parties weren't allowed to remarry, officially at least anyway. So in any event, yes, divorce was very difficult in this period, and that is an important part of the story. But there is another crucial aspect, and that is this practice, I argue, wasn't just about getting around the extreme difficulties of getting a divorce in the period, but it was actually also about getting around or coping with the fact of property law during the period. So the basic property law of the period stipulated that so women had the same property rights as men before they got married. But upon getting married, virtually all of their property rights became the exclusive property of their husband. So they didn't own anything. Any assets they had, any wages that they might have earned or that they would earn in the future, any property that might come to them in any form in the future became their husband's exclusive property. And that's important because, again, going back to the Coase theorem idea, ordinarily we would say, look, if say, a woman wants to get out of her marriage more than the husband values retaining the marriage, even if the law basically makes it really hard for them to get a divorce. For instance, say it requires the husband's permission in order for that to happen. The wife, the would-be single woman, can just purchase his consent, that there's a mutually beneficial bargain that can occur there that would allow for an efficient marital dissolution, giving the female the right to exit marriage. And that's right. I mean, that makes perfect sense. But the problem for Industrial Revolution era English women was that, as I was just describing, because of marital property law, they overwhelmingly had no property rights with which they might enter such an exchange with their husband. Everything that they might use to bribe their husband for consent to at least de facto exit the marriage, say to live apart from him, was already their husband's property. And so, the idea is that, well, who could these women potentially use to secure, if they really want out of the marriage more than their husband wants to remain in, then there are prospective gains, if only for dissolving the marriage, letting the woman exit, if only there was some third party in this case who could basically act on the wife's behalf, whose interest was aligned with the wife, who had the property rights to pay the husband what he would require to give the wife permission to exit. And that, of course, is what we call, anyway, or what I call in the book, suitors. These are people who valued an existing man's wife more than that man valued her, and because he was male, had the property rights with which to purchase her right to exit. And that's what wife sales were. They were indirect Coasean bargains that gave wives, in this peculiar legal context, the ability to exit unhappy marriages where they otherwise would not have had the ability to do so.
Okay, so it's a Coasean bargain where people can get out of unhappy marriages, and it's unfortunate. I think we can all agree that the system of property rights with respect to women was very undesirable, and we're glad we've got away from it. But at least there were ways around it. I'm reminded of the antebellum South, where sometimes slaves would try to save up to buy their freedom from their masters, and then the master could turn around and argue, actually, since I own you, I own all your savings as well, so you can't buy something, you can't buy your own freedom from me with money that is rightfully mine. Sort of a perverse situation where the lack of property rights is self-enforcing, self-sustaining, even if it's not economically efficient.
Yes. If I can just add one quick point to it, which I think is critical, which I overlooked in your analogy to slavery, which is, I think, a good one in the respect in which you raised it, but is importantly different from the English practice of wife selling in another respect, which is that, unlike the case with slaves, the women who participated in these sales, in these public auctions for them to the highest bidder, did so voluntarily. So they could veto any potential transaction. If I bid on some lady and she thought, I don't want to be with that guy, I don't value being with that guy more than I value being with my husband, as detestable as I may find him, she could nix the sale and it wouldn't happen. So her consent was critical in order for the sale to go off, which is, of course, not true with slavery. Crucial difference.
Yeah, it seems like you wouldn't just have, an open auction to a total stranger. It seems like probably, it would be a situation where there was a pre-existing affair, or the suitors would not just see the ad in the newspaper and then go buy a wife. They would probably already know this person, or so it seems. Is that probably correct?
Yes, it is. It seems that many of the sales were prearranged essentially between a wife's lover, as you're getting at, and the couple involved. That was definitely true, which makes sense because of course, often it would be a wife's lover who presumably valued her the most highly among the would-be potential would-be suitors. But not every case was involved a lover. Some men, as maybe as hard as it seems to believe, it seems actually hired the services of agents who would go to these auctions. So the men seeking wives didn't even go to the auctions themselves. They would hire these third parties who would then go and bid on, I guess, the women that they thought would be the mate most most highly valued by their employer. So some people actually picked up wives without having had prior interactions with them, and effectively using the judgment of a third party to determine who would be their new wife, which is a kind of remarkable thing.
And this is a monogamous society, so you can't just, collect them like Pokemon and spend more time with the ones you like.
That's right.
So
That's right.
It seems like a very risky, but I guess you could just resell them if you if you didn't enjoy their company. Do you know off the top of your head what kind of prices were happening in these markets? Was it was it a big chunk of a regular person's earnings, or were they sort of more nominal amounts, smaller amounts, mostly just to get around the divorce issue and transfer just a little bit of money?
So it's a bit hard to say. It's something that we looked at. It's a bit hard to say what the sort of relative value of these things, the prices paid, were, in part because a lot of the transactions were not, or were not exclusively, I should say, monetary. They involved payments in kind. So it might be, £2 and a donkey, or, a quart of ale and, 6 pence, or whatever the price would be. And that makes it harder. It was harder for us to try and figure out, how to monetize the in-kind contributions, which might be significant, as I say, in some cases. So what we ended up doing, which gave us an extremely imperfect look at things, was to just focus on the monetary side. And there is some good variation there. Prices, the further back in the past you go, it seems, I think the real prices were higher than the closer to the end of the practice you go. But my general impression is that the sums were not trivial, but not enormous on average. So if you sort of just look at the real monetary figures, they look kind of low, pretty low, very low in some cases. But you also have to remember that the people who were appealing to this practice were overwhelmingly coming from the bottom of the socioeconomic ladder. So much so that it's hard, I think, to get a sense of like what their average earnings would be so that we could perform a useful comparison. So keeping that in mind, I think the other element that needs to be thought about here is, well, how important was it, or how much did the husbands, want to remain in the marriage relative to the wife? In other words, what was their reservation price for letting go? And they did, I should point out, the husbands at these auctions set reservation prices. So they weren't for the most part, it doesn't seem that they were willing to take anything in order to let them go. So they set a reservation bid, and the minimum bid in order for her to go, she not only had to agree to be partnered off with, to now enter a new marriage with the guy who made the highest bid, but his bid had to meet the reservation. So I think probably a good part of the variation that we see there comes from how much husbands may have valued remaining in the marriage relative to what was being offered. And that could be influenced by a whole host of complicated things that included, for instance, what the husband's legal obligation was to support her. So the law required that husbands support their wives while they were married to them, quote, consonant with their means. And, these guys weren't rich guys. So that's probably not a lot, but as a share of their already meager wealth, it could have been significant. The same thing would have been true for the couple's children, or the women's children, if she had any. So the presence of children could bear on the eagerness of the husband to, be rid of her or not. And on the other side of things, children could be, and I think often were actually more than just a cost. They were an important asset because you could kind of, put them to work essentially as another source of income. So that could be something that might make you want to hold on to your wife, even if you knew, say, she was cheating on you and you didn't really like her very much. The all love would have been lost in the marriage. The fact that there were kids, could play a role here that might make you want to keep her around too. So a lot of different factors that make it hard to know for sure, I think, that make me less comfortable about giving a sort of pat answer about, what the height of these prices were. But the figures are all there. So they're reported in the book and some of my other scholarship on the practice. So interested listeners can look at it and form their own judgments.
Wow, that isn't that romantic? You imagine this is my wife. I traded 6 goats for her. Or I know my wife listens to this show, so honey, I would trade at least 7 goats for you. Just a side note. So let's we have time for one more of your chapters. Do you have a favorite one that we haven't gone through? That there are so many good ones, but I'm having difficulty choosing. Do you have one that's particularly interesting?
Oh gosh, I think they're all. It's hard for me to choose too. I think I don't know. I mean, I think the strangest one, in a way, the one that all of these, by the way, I should point out, took me. So back to, this is for a sidebar for a second. Back to the overarching theme of the book, that all of these practices reflect rational behavior and in general are socially productive. The key. If you take that approach to understanding unusual, or in fact all human behavior, any human behavior, whether it seems normal or not, the key to understanding differences across different practices and people's behaviors more generally then comes down to understanding differences in the relative prices that they confront and in their constraints. And when you're dealing with these historical practices, particularly unusual ones, that means you have to spend, in order, if you want to understand them from this perspective, to try and resolve the puzzle that they pose, a ton of time learning about all of the particular historical details of that environment, of that context, that might have been things that influenced the constraints or prices under which people were operating. So as a result, all that was to say that, with all of these things, it took years in each case for me to do that research and then to think about, how it might be that these things came together. And the one that comes to my mind that maybe was the most frustrating, it's also probably may not be the best one for us to talk about. It's easier to read about, I think, in the book. I'm happy to talk about it, but it's the most involved in a way, was the criminal prosecution of insects and rodents in Renaissance Italy, Switzerland, and France. That one I might have been 4 or maybe even 5 years of learning more and more about the environment, the constraints, what was happening that people confronted that could possibly make sense of it. And that's because I think it stands out, in my mind at least, as possibly the most batshit crazy thing a person could imagine.
Yeah, and for context, so you have churches putting vermin on trials. So I'm not sure how exactly it would work, but you find a rat in your cellar eating all your, or in the granary eating all your food, and then you don't just kill the rat, or maybe you do kill the rat, but then you put him on trial, and are you sort of treating them like humans and sentencing them to having a judge and everyone having a whole formal proceeding? It seems very strange, and I don't know how you could make economic sense of it.
So the crucial piece of it is that, yes, they were treating the vermin just like people. They were treated like legal persons. So they had court-appointed attorneys, defense counselors, who argued on their behalf at their trial. All of the ordinary legal procedure was applied to them. They'd be granted continuances. If they were convicted, they would be sentenced. I should point out that some of the defense counselors, by the way, weren't just, defense lawyers that represented people ordinarily. They were some of the most distinguished jurists of their era. One of them went on to become the president of the Parliament in France, Parliament of Paris, and it's just remarkable. But one important item here, so it wouldn't be that if you found a rat, say in your cellar, eating, or in your field eating your wheat, let's say, it would be infestation. So it wasn't one rat, but if you had like a horde of rats, or if you had a plague of locusts, it was sort of like this was a means of an attempt at pesticide to cope with infestations that farmers confronted. Not unlike farmers today can confront infestations, even with scientific pesticides. So they would communities that were afflicted by these infestations would appeal to the equivalent of sort of like what we would now think about as like a district attorney in their district. They would appeal to him, and then he would then bring their complaint, a formal complaint written before the court exercising power in that jurisdiction. And these were ecclesiastic courts in the period that exercised such jurisdiction. So they're operating on behalf of the Catholic Church. And, the district attorney would basically plead with the court to consider the case. And sometimes, by the way, the court dismissed the case out of hand. They would just say, no, the infestation reflects the fact that, we think God wants the pest to be there, which means they have a right to be on your property. So your claim of, say, trespass is invalid. So you're going to be non-suited. But in other cases, many other cases, the court would take up the case and then assign the vermin the lawyers, and then have the prosecuting attorney come forth, and they would make their cases. And the legal cases, this wasn't a one-day affair. These could be anyway, and often were drawn out for months. And then the whole show would finally end in a verdict against, or usually against, not always, but conditional on it having made it to trial. Overwhelmingly, the vermin would be found guilty of the crime of which they had been accused, say trespass, and then they would be sentenced. And the sentence, which is befitting since it was an ecclesiastic court, was, if you were found guilty, excommunication and anathema. So these, which is another remarkable aspect of the practice, because presumably locusts were never communicated in the first place, and don't have souls, but the church treated them as though they did, and that was the punishment, which then the critters would be informed about by bringing some of them before the bench to tell them and remit them to share the news with their colleagues. And sometimes placards essentially would be posted up in wooded areas or in the infested area in order to notify the locusts, which I guess the courts were presuming could read, and that's how they would find out that they had been convicted.
I can't make heads or tails of that. It doesn't seem like there could be any rational explanation for doing this, but you've got one, presumably.
I've got one. So, as I say, it took a very long time to come to it, but when I hit on it, it made a ton of sense to me. And the further and further I got into trying to sort of test my theory with the evidence, the more and more I became convinced, until ultimately I was quite convinced that this was what was going on, which is how I wound up writing about it and putting it in the book. A very short and therefore possibly not convincing explanation, but as I say, this one is more involved to get into, but it is as follows, is that you have to understand that during this period, so this practice started, well, we're not exactly sure when it started, but it certainly seemed to take off in the period before the Reformation. So it extended over into the period of the Protestant Reformation, but began well before it. It was in its heyday around that time. And what you had in the pre-Reformation period were these basically Proto-Reformation heretics, some of whom were running around. They were relatively small sects, but in certain areas they were more numerous and they had more influence than others. For instance, in the parts of Italy, France, and Switzerland in which these trials against crickets and cockroaches and rats and so on were conducted. And these heretics, their important heresy, I think, one of their most important heresies, was twofold. On the one hand, they denied that the church had the power to actually divinely curse citizens through excommunication or anathema. That the church couldn't ask God to basically, damn you to spend more time in purgatory, which, by the way, the sect also denied the existence of, or damn you to hell, or cut you off to the path to salvation via the Holy Mother Church. So the heretics denied that Ecclesiastics had that power. And the other thing that they denied was that citizens owed the Catholic Church tithes. Tithes were, of course, a form of taxation levied by the church in this period on the lay population. That was a primary source of church revenue. It was levied ordinarily in kind on farmers' produce. So a certain part of a certain number of sheaves of your wheat or your crops. And the problem that one of the problems that the church during this period confronted was that, just like today, people wanted to evade their tithes, just like people want to evade their taxes. They weren't really happy about declaring, everything that they owed to the church, and so they would try and hide part of it, and all sorts of different ruses that they engaged in that I discuss in the book. The church's solution to that problem was, since it was hard for them to detect whether or not evasion was happening, was to invoke God, to say, you know what, we can't see what you're doing, potential tithe evaders, but God sees everything. And so, he knows if you're evading. And if you're evading, then here are the bad things that happen to you. You'll be excommunicated, you'll be anathematized, and so on. These divine curses. So these heretics, the Proto-Reformation heretics who are running around, who are spreading the idea that all of this is BS to citizens, are posing a serious threat to the church's coffers, basically. Because if people don't believe in the divine sanctions that support tithe compliance, and people, furthermore, don't believe that they have to pay their tithes because these heretics are denying that people need to pay the church tithes, then the church is, in a serious problem, at least in these areas. And so I argue that the church used the prosecution of vermin as a way to essentially bolster citizens' faith in the divine punishments supporting tithe compliance. And the way that they did that was by manipulating the duration of trials, which could generate the kind of evidence that would have that effect.
Okay, so you put a locust or a swarm of locusts on trial, and you excommunicate them. And how does the length of trials relate to people's faith in your ability to bring, divine judgment on them and these pests?
So the longer a trial, so locusts or any insect or rodent for that matter, is likely, in fact, will with certainty eventually either die or depart the property that it was formerly plaguing. It might find better feeding prospects somewhere else. The winter could arrive, killing the pests. The natural predators of the insect or rodent might appear in the area, driving them forth. It's why pest infestations don't last forever, no matter where they are. So by manipulating the trial's length, in particular by lengthening the trial's duration, what the church courts that were conducting these trials, could do is basically improve the odds that the afflicting vermin would die or depart under the specter of the threat of being convicted and consequently sentenced via excommunication and anathema. The very same sanctions, recall, that the church was using to try and get people to pay their tithes. So if the church protracts a trial for a little while and the locusts depart, people may now believe that the reason that the pests departed, and of course the courts would claim credit for this, was that they were under the threat of the church's imprecations. They didn't want to be anathematized or excommunicated. Or in fact, that if the sentence had already been passed, that is what happened to them, and so they were perishing as a consequence. So it was generating evidence that the same sanctions which were used against the bugs that were being used to support tithe compliance were legitimate. The church, against what the heretics were saying, really did have this power after all. And if you believe that, or if your faith that they really have that power to punish you in that way if you don't pay your tithes goes up, well, you're more likely to pay your tithes.
Okay, so it's like if I claimed I had a miracle cure for the common cold, and I give you this pill 5 days into your 6-day cold, you're gonna think, wow, it must really work because 1 day later my cold went away. But of course, what you don't know is that the cold would have gone away anyways. So similarly,
exactly.
You have the trial and the locusts that were going to die off or move on anyways. move on during or at the conclusion of the trial, and that convinces people, like the pill just before the cold would have ended anyway, the trial just before the vermin infestation would have moved on. It makes people think it's causal when really it isn't.
Yes, that's right. Which again works conditional on their superstition. It works conditional on their superstition in the sense that the farmers are only appealing to the court in the first place because they think that there might be some chance that the church actually has this power. So they already believe it's possible. You don't have to generate the belief out of thin air. If people don't believe at all, they won't bother bringing the infestation to the court in the first place. So they're outside the church's power. But if you think that maybe there's a chance, right, there's some positive probability that what the church is saying is real, that's why you're bringing the pests. Well, now the church can basically leverage that belief and try and increase it to get you to pay more tithes. But this part of the reason the story gets much more complex is that there are limits to this, right? So using your cold example, suppose that a cold's always only lasted 6 days, right? Of course, that's not true, but suppose that they did and everybody knew that. Well, then, if you gave me the cold medicine on the 6th day and my cold went away, I would know that it didn't have anything to do with the fact of your magical medicine. It was just because colds end at 6 days, right? Mm-hmm. The same thing was true, in a sense, with the farmers that were appealing to the ecclesiastic courts to rid them of unwanted pests. They didn't know, there was no, a pest infestation always lasts X amount of weeks or months, or days for that matter. Nobody knew that because there is no answer to that, right? It depends. But they were aware of the fact, obviously, as farmers, that pests don't last forever. And so the court couldn't infinitely protract the trials and then claim credit for the pest's death or departure because farmers would know that wasn't true. What the court had to do was to sort of prolong the trials somewhat, but not too much, such that Mother Nature was the obvious and certain cause of their departure, which would allow them to claim some credit. In effect, they were kind of, both generating and leveraging, again, the kind of noisiness of the process of itinerant critters as a way to generate plausible evidence for what they were doing that couldn't be dismissed as the certain product of Mother Nature, but instead might be construed as evidence for the effectiveness of their divine sanctions. And that involved a kind of careful manipulation of the trial's duration, which was completely under the power of these courts. They determined the plays that the trials followed. Remember, before I said sometimes the trial would barely get off the ground, the court would dismiss it, or they could drag it on for months and months and months. So they were trying to kind of playing this game, this balancing act of how long they needed to draw it out such that on the one hand, the pest would actually go away so they could claim credit. But on the other hand, the trial wasn't so long that the outcome, even though it was what they claimed would happen, wouldn't be convincing as evidence for the effectiveness of their supernatural sanctions.
Well, that's certainly clever, and I didn't think there could be an explanation, but yeah, that seems very plausible and very as with the rest of your book, it aligns with the incentives of the people making the choices and was presumably somewhat effective at manipulating people's beliefs, at least for a time. Yeah, that's very interesting. So on that note, we're out of time. The book is WTF, An Economic Tour of the Weird, which I'll have a link to at economicsdetective.com at the show notes page. Peter Leeson, thanks for being part of Economics Detective Radio.
Thank you so much for having me.